Turning now to a major ruling from the Supreme Court of Canada. An Ontario high school teacher has been found guilty of voyeurism. The teacher used a camera hidden inside a pen to secretly film the chests of female students. CBC's Catherine Tunney has more now on the decision and what implications it may have.
Well, Jennifer, it is an interesting case that raises some interesting questions about privacy and voyeurism in a world where basically everyone has a camera just right in their pocket and a phone. So just a quick review of the facts of the case. As you said, this teacher, Ryan Jarvis from London, Ontario, had a camera and a pen, and he was using it to film the chest and cleavage area of some of his students. About 27 students in total, and they ranged between the ages of 14 and 18. Now, when the case went to trial, Mr. Jarvis admitted that he took those recordings. That was never in question and doubt. But he was charged with voyeurism, which is a relatively new charge. It came in 2005, and it's two-pronged. There is the element that it has to be the crime has to be done with a sexual intent, but also that it has to have violated a reasonable expectation of privacy. And the lower courts disagreed on that fact, and that's what the Supreme Court was asked to look at. Whether students in a school, which is a quasi-semi-public area, have this reasonable expectation to privacy. And this morning they came out unanimously saying that yes, those students are entitled to not have their chests shot by their teacher, and they found that Mr. Jarvis was guilty of voyeurism.
Catherine, because of the broad-ranging potential implications of this and the whole question of privacy, plenty of groups will be now studying closely this decision. What reaction are we hearing so far?
Yeah, I've talked to a few groups because, as you said, this case, even in his writing, Chief Justice Richard Wagner talks about how this definition will impact public spaces. He talks about, someone using a cell phone to film up a woman's skirt on public transit, a drone maybe gathering images of sunbathers on a beach who are unsuspecting. So this case could have some wider implications. I spoke to one of the interveners, Jillian Nachu. She's with the Women's Legal Education and Action Fund, and she said that this case, she was very pleased with the decision this morning, and she said it lays out a test for future cases that deal with privacy and sexual violence. And here's more about what she had to say.
It has intentionally extended protections to women in all sorts of public and quasi-public spaces. Going forward, each case will turn on its facts, as cases always do, but this gives trial courts across the country scope to recognize that this is about more than just privacy, that it's also about sexual integrity.
So that's her take on it. I also spoke to Ontario's privacy commissioner. He called this the right result, and he was very happy to see that the court took into consideration context. It's not just about public versus private spaces, that the context also matters when you're dealing with voyeurism. But this case did come out this morning, so I'm sure we'll hear more from more groups as the day goes on.
CBC's Catherine Tunney in Ottawa. And just into us, the lawyers for Ryan Jarvis have responded to the Supreme Court's ruling. They are calling the judgment, quote, troubling. They say Canadian criminal law has traditionally sought to protect and preserve the distinction between offensive behavior and criminally offensive behavior. The majority's decision risks eroding this distinction and capturing conduct which, while offensive, ought not to attract the personal ruin, stigma, and deprivation of liberty that accompanies a conviction for a criminal offense. Jessica Zita is a criminal defense lawyer in Toronto, and she has been closely following this case and joining me now. Thank you for being here.
Thank you for having me, Jennifer.
I understand you've reacted to this in two ways. One as a woman, one as a defense lawyer. So first of all, how you reacted to this ruling personally as a woman.
As a woman, Jennifer, I have to be honest, just looking at the facts of this case, how it came to be, as a woman and as a human, I am comforted by it, but my professional opinion as a lawyer differs significantly from that.
Well, let's talk about your concern then as a member of the bar. First of all, I'll read a short statement from the lawyers for Jarvis, and they say the majority has erected a hyper-nuanced framework that may prove to be inaccessible to both laymen and those with legal backgrounds. The public would be rightly concerned that the court's expansive definition of circumstances giving rise to a reasonable expectation of privacy may cast the net of criminal liability too wide. Does that distill your concern as a lawyer?
Yes, Jennifer, that thought is prevalent among the criminal bar right now. The problem we're facing here is that this ruling from the Supreme Court today on what they found to be a reasonable expectation of privacy is beyond the scope of what was intended by Parliament. Parliament, did not criminalize the filming of or the observing or filming of people in a public setting. In this case, the subjects were in a school that was known to be highly supervised under surveillance with cameras at all times. So arguably, this was a very public setting, and they should have known that. Is what the Supreme Court is the statement that was made today. The problem, though, is.
So you find it's too broad? Is that the problem?
The problem is that it's too broad, and it opens the floodgates to what could be considered criminal behavior. In criminal law, there's a principle called the fair notice doctrine, where everyone needs to know the conduct that would be considered punishable. In this case, based on what the Supreme Court said today, we don't know what that could be anymore. If I accidentally take a photo of someone and someone else appears in the background and they're bent over or doing something like that, and it's seen to be for a sexual purpose, that this pronouncement by the Supreme Court could mean that I've infringed upon the reasonable expectation of privacy. But really, they're in a public setting, and there's no reason, the Parliament didn't intend for that. So it'll be interesting to see how this plays out. I think the concern is that we're in dangerous territory now.
It did take a while to get to where we were today. A lower court acquittal, then a court of appeal ruling that backed the lower court. So help us understand why the Crown would be so adamant that a conviction was warranted here.
Because the facts of the case, Jennifer, are they are uncomfortable. And we're talking about schoolgirls that are being filmed by a teacher with a pen. That subject matter that makes the public uncomfortable and makes the public uneasy. And the fact that there was an acquittal entered once at the lower court and then again by an appellate court is something that the Crown. I should be clear, there was a dissent at the Court of Appeal that allowed for the Crown to pursue this at the Supreme Court. And I think that they felt that discomfort and they felt that unease and the public unrest in the decisions that in the lower courts, and they needed to explore that.
This relates to an aspect of law that you have written about, publishing intimate images without consent. It's sometimes referred to as revenge porn, and that has been a problem that's ended up in the courts. This case is similar, but of course with differences. Can you help us understand the differences then? So there are different sections of the code. Voyeurism is section 162 sub 1. Publishing sexual images is section 162.1. And the main difference is an issue of consent. So if, for example, a partner takes a photo of me and posts, and I know they're taking a photo of me in a compromising state, that's perfectly fine. But then if they go behind my back and post it, they publish it, I'm not consenting, that's illegal. And that's what that captures. We don't have that issue of consent in the voyeurism provisions. The issues we have there are the factors that need to be proven there. Was this image captured secretly, surreptitiously? Was it captured for a sexual purpose? And then there's a number of circumstances for what the subject that was captured. So obviously consent is not an issue to be looked at under that provision. You've given us a sense of what a delicate area this all is that the courts are having to navigate. Thank you so much for your insights on today's ruling.
Thank you for having me, Jennifer.
Criminal lawyer Jessica Zita joining me in studio.